A crazy decision out of the United States Court of Appeals for the Fifth Circuit. They worked really hard to try to apply Bruin and Rahimi to a 18 U.S.C. 922 felon in possession case. But I think they screwed it up. Why? Because they relied upon, ready for this, horse thievery laws. Horse thievery laws. And that's just not going to cut it when it comes to a basis for taking away someone's right to keep and bear arms under the Second Amendment. Let's get geeky and break down this Fifth Circuit decision in Diaz when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. We never want to get complacent and think government will protect us. Learn the lessons from the Jews throughout history and Israel in modern history. A lot of important stuff in that small tome, Israel Disarmed, available on Amazon. Okay, before we get to the substance of this video, if you guys are going to be out there in San Diego next week for the Second Amendment Foundation's annual Gun Rights Policy Conference, feel free to stop by and say hello. I'll be speaking on a couple occasions out there and doing a book signing. Looking forward to talking about the Second Amendment and meeting a lot of you people out there in San Diego, California in a week. All right, folks, now let's get down to brass tacks here. The Fifth Circuit Court of Appeals out of Texas and Louisiana, which is a pretty good court when it comes to our right to keep and bear arms in the Second Amendment, I think ball dropped something. I think they ball dropped a case in the United States versus Ronnie Diaz. This is a case that was just decided by the Court of Appeals down there in Texas, Louisiana. And it involves the application of the federal prohibited person statute dealing with felons in possession. That's 18 U.S.C. 922G1 that says that if you're a felon, as that's defined by federal law, because remember, some misdemeanors that you can be convicted of qualify as felonies under that federal statute, 922G1. And if you are convicted of a quote-unquote felony, as that statute defines it, you lose your gun rights for the rest of your life unless they are restored, which is very difficult to do. Now, Ronnie Diaz doesn't seem like he may be the best neighbor on the block. By virtue of his prior criminal record, he had been involved repeatedly with certain drug possession charges, but in particular, and this is particularly important, in 2014 and 2018, he was engaged in stealing a motor vehicle and another instance of attempting to steal a motor vehicle. Now, this is very important to hear what I just said. Stealing and attempting to stealing a motor vehicle in 2014 and 2018. And that's because he was convicted of that crime early. And then in the year of our Lord 2020, Ronnie Diaz was pulled over with another traffic stop, and he was found to have a gun, a .45 caliber pistol, as well as some marijuana and some meth in his drug. He was arrested at this point, and he was charged with 18 U.S.C. 922G1 for being a felon in possession. The underlying predicate felonies were, of course, among other things, most importantly, I would say for this case, that he was arrested, that he had previously been convicted of and sentenced to prison for stealing motor vehicles. Now, you'll see why that's so important when we get to the analysis in just a couple minutes. So what happens next? So Ronnie Diaz, the defendant, asked for a bench trial. He's convicted of being a felon in possession of firearms. He asserts his Second Amendment rights. The district court denies it. He goes up to the U.S. Court of Appeals for the Fifth Circuit and argues that under the Rahimi precedent and the Bruin precedent, he should not lose his right to keep and bear arms, and the 922G1, as applied to him, is unconstitutional because his prior criminal conduct that gave rise to his criminal convictions was simply stealing a car or attempting to steal a car, and that has nothing to do with firearm regulations and is no basis for denying his right to keep and bear arms, and therefore he cannot be convicted in 2020 of possessing of firearms because he had the right under the Second Amendment to possess the firearms because nothing he did prior to that constituted something that would make him a physically violent danger to another person. Now, the Fifth Circuit, in analyzing this, I think, screwed this up in several ways. And I don't think that the Supreme Court would agree with what the Fifth Circuit did here, although I think the Fifth Circuit worked hard to try to get it right. I don't think this is a situation where you had three anti-gun judges who bent over backwards to misconstrue the Second Second Amendment. I think, they were trying to get it right, but I don't think they did for several reasons. Just to remind you that once the text of the Second Amendment is implicated, the burden shifts to the government to come forth with historical analog laws proving that going back to the time of our founding, there is a historical tradition of a type of firearm regulation that's analogous to the modern-day gun law. The modern-day gun law under 922G1, obviously, is that you can be disarmed for the rest of your life based on some crime, specifically a felony as defined by Congress. Now, what happened here is that there was a search for whether or not there's a historical tradition of firearms regulation that would justify this law, and specifically to justify the fact that you could disarm Mr. Diaz for life by virtue of the fact that he was convicted of stealing a car or attempting to steal a car. And the court ultimately said that yes, it was constitutional to apply 922G1 to Mr. Diaz. Why? Because there were allegedly historical analogous laws on the books at the time of the founding that banned horse thievery. Did you hear what I just said? Horse thievery. And if you were convicted of stealing a horse at the time of the founding, so the court said you could, in theory, be sentenced to death. And by extension, if you could be sentenced to death at the time of the founding for stealing horses, it's perfectly fine today in the 21st century to disarm somebody for life if they steal a car, because the analogy to a car theft statute in the 21st century would be stealing horses in the 18th century. Now, this is wrong for many reasons as I see it, so I'm going to walk you through it. To begin with, the first error made by the Fifth Circuit is the Fifth Circuit did not put the burden of establishing this historical tradition on the government. And why do I say this? If you look at the opinion, which I'll put a link to down below in the description on page 14, this is what the court writes. It writes, quote, our own research, hear what I just said? Quote, our own research reveals that those convicted of horse theft, likely the closest colonial era analog to vehicle theft, were often subject to the death penalty. And then they cite to an article in the Law and Historical Review involving the history of Virginia. Well, is that allowed? Is a court allowed to do its own research? Well, the answer is generally no. Why do I say that? Because if you look at footnote number 6 in Bruin, guess what footnote number 6 in the Supreme Court decision in Bruin says about courts doing their own research? They say that the burden of proof is on the parties to do the research. Here's what the Supreme Court wrote in Bruin that speaks exactly to what the Fifth Circuit should not have done, i.e., do the work of the parties themselves. Here's what the Supreme Court wrote in Bruin. The job of judges is not to resolve historical questions in the abstract. For example, in our adversarial system of adjudication, we follow the principle of party presentation. Courts are thus entitled to decide a case based on the historical record compiled by the parties. Do you see that? Footnote number 6. The courts are supposed to look at the historical record compiled by the parties. And this is particularly important in my view when you're dealing with a case like this, a criminal case, because the burden of proof is on the government to not just show that someone's guilty, but also to justify these criminal laws, which is what 922G1 is. And yet here you have the Fifth Circuit Court of Appeals going out and doing work to justify the criminal statute, where it's the burden of the government to do their job. Courts should not be doing the job of the government when the government is the one that's supposed to, prove that people are guilty and justify their government-created gun control laws. So that's the first mistake the Fifth Circuit made in this case of Diaz. The second thing is they only rely on and cite to conceivably 3 statutes, 3 colonial era statutes, one of which arguably is not even in that time period. Specifically, if you look at page 14 of the opinion, they cite to a statute from Massachusetts. They also have one from New York, and they also cite to an article that discusses supposedly a law in the state of Virginia. Okay, and by the way, the Massachusetts law is in a book called The Colony of Massachusetts Bay Laws, 1630 to 1692. Now, 1630 to 1692 is almost 100 years before the creation of our country, the founding, the Revolutionary War, and the creation of the Constitution and the Bill of Rights in 1791, right? So one wonders if even this Massachusetts law that they talk about is applicable, because that's very, very early, very English-oriented, not so American. But let's, for the sake of argument, assume that the Virginia law, the New York law, and the Massachusetts law, I should say, it was the Massachusetts law that was from the 17th century, by the way. But let's take the Massachusetts law, the Virginia law, and the New York law, and say those three analogs are possibly analogs. Well, guess what? None of these three deal with firearms, right? And what is the standard, folks? The government bears the burden to show that there is a historical tradition of what? There is a historical tradition of firearm regulations. Historical tradition of regulation of firearms. But if you look at these three statutes they cite to on page 14, none of them speak to firearms. So how are these how can three laws, one of which is not even from the relevant time period, give rise to a historical tradition of firearms regulation? I would say that is a stretch. But let's go beyond that. Let's assume these are, for the sake of argument, somehow related to firearms regulation, which I don't think they are. But let's pretend they are for the sake of argument. Well, guess what? The Fifth Circuit again screws up. Why? Because they don't follow another command by the U.S. Supreme Court. Here's what the Supreme Court wrote in Bruin, where it specifically says that three laws are not enough to create a historical tradition of firearms regulation. Here's what the Supreme Court wrote in Bruin on the point of three laws is not enough. It wrote, quote, in the colonial era, respondents, that would be the state of New York and Bruin, point to only three restrictions on public carry. For starters, listen carefully, for starters, we doubt that three colonial regulations could suffice to show a tradition of public carry regulation. Wow. Literally in the Bruin case, the Supreme Court says three regulations is not enough to show a historical tradition of firearms regulation. And here you go in the Fifth Circuit down there in Louisiana and Texas, right? On page 14, they're talking about three laws. Seems to be a problem, right? Seems to be not sufficient. Nevertheless, the Fifth Circuit used those three laws to uphold this conviction of Mr. Diaz, despite the fact the Supreme Court says three laws is not sufficient to show a historical tradition. The next point is that there's no showing here that Mr. Diaz is physically violently dangerous toward third parties. Remember we talked about Rahimi several times? The Rahimi case dealt with a different part of 922. That was 922G8, where there was a court finding that someone was a violent danger to a third party and subject to a domestic violence restraining order, that those are constitutional, okay, for the sake of that case. The point being was there was a court finding that someone was a physically violent danger to a third party. And in those circumstances, you could temporarily disarm somebody while they were dangerous, in that state of being dangerous. But there's no finding of Mr. Diaz on this record of being dangerous to anybody at all. Yeah, it's not a good thing to use marijuana. Yeah, it's not a good thing to walk around with meth. Yeah, I get it. You shouldn't steal cars. And you shouldn't try to steal cars. And if you do that, yeah, you should be punished. But that seems to be a far cry from a finding of physically violent dangerousness that the Supreme Court seems to be demanding in the Rahimi case. So yet again, the Fifth Circuit, I think, just didn't get it right with this conclusion. All right, so to wrap this up, I think the Fifth Circuit got this wrong. Now, there is some brief discussion, of course, about the two bodies of law, not laws, bodies of law that were well established at the time of the founding. Those were what are known as the Going Armed Statutes, which said if you went armed to the terror of the people at the time of our founding, which basically is an anti-terrorism statute. If we ran around and terrorized the people with weapons, you could be disarmed because you could go to prison. Okay? And then you had what really is a confirmatory analytic, the surety laws that says that, again, if you are found to be a violent danger to another, you could be forced to post a bond after a finding that you were a danger to another party. But again, both in the surety laws, and there were many surety laws at the time of the founding, they were really in the common law. Eventually they were enacted in a statute in the early 19th century, but they were really in the 18th century were well-established common law rules about posting bonds and sureties. And then, of course, going armed goes all the way back actually to the 1300s in England with the Statute of Northampton, which you don't need to know a lot about for the purpose of this, beyond saying that you cannot go around terrorizing people because you can go to prison for that. And that was always the case for hundreds and hundreds of years, and certainly was the case during the founding of our country. So with all that said, it seems to me those laws don't speak to Mr. Diaz's situation. Again, stealing cars is not good, but I don't think that equates to dangerousness, and there certainly was no finding on this record of that. And again, saying that stealing cars today is the analogous to stealing horses in the 18th century, I think is also a bad analogy, because keep in mind that if you stole a horse in the 18th or 19th century, you were really depriving somebody of life in the sense that if you took their horse away, they couldn't ranch, they couldn't farm, they couldn't get to the town. You were really taking their ability to earn a livelihood away. Now, in the modern society, yes, it's bad for someone to steal a car 100%, and you should be punished for that. But, I'm not quite sure that people are going to starve or die if someone steals their car today. I don't think that was the case in the 18th and 19th century, where many people relied literally to stay alive by using horses to hunt or to do their job or to get to town or the market square to shop, whatever it was. Horses were far more important at the time of the founding, I would suspect, than a car is today. Let me know if you disagree. But again, I think drawing the analogy to horse thieving at the time of the 18th century versus car stealing today, while both are crimes, I'm not sure one is a violent crime that can justify being disarmed for life, which is what 18 U.S.C. 922 G1 does, according to law. And the Fifth Circuit seems to think that that perfectly applies perfectly fine to Mr. Diaz here. All right, folks, hope you learned something here today. Make sure you subscribe and like this video. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.